You're listening to the Common Interest Podcast, where we discuss condo, townhome, and homeowner associations and the issues affecting them. We're produced by the Community Associations Institute of Illinois. This podcast is made possible in part by our Diamond Annual partners, Itasca Bank and Trust and Wintrust Community Advantage. Thank you. Welcome to the live stream. Today, our live legal update on COVID-19 and related issues for community associations in Illinois. This is really an opportunity that we at CAI Illinois wanted to pull together an attorney panel to keep us updated on the developing issues surrounding COVID-19. So we have a list of questions, a list of topics that we're going to be covering today, but also we want to make sure that we get to your questions in the chat. You might have things that are going on in your association, and the answers that we're able to provide may not be a specific answer to your question. It's meant as that general guidance for what your association might consider doing. And if you're listening to this after April 6th, it's April 6th right now at 2 p.m. We're planning on going, we're scheduled to go to 3:30. If we're hot into topics, we might continue a little bit after that, but about 90 minutes is what we scheduled here for today. But if you're listening after today, this video is going to be available on YouTube following today. And then also tomorrow morning, this live stream will be released as an episode of the Common Interest Podcast, which you can get on Spotify, Stitcher, Apple Podcasts, Google Podcasts, wherever you get your podcasts from. You'll be able to find it there. So I guess without any further ado, let's introduce our attorney panel. So starting on the left, we have Nick Bartson from Altus Legal. I'll have you guys just introduce yourself, tell us a little about yourself and about your firm.
Thanks, Brandon. Thanks for having me. My name is Nick Bartson, Nick Fine, and I'm the founding partner of Altus Legal. We exclusively represent Illinois condominium and homeowners associations. Very glad to be here. And I just got a text from my partner who told me that I'm looking a little bit too serious. So I'm going to try to line up with that.
Okay, and my name is Michael Kreibich. I'm a partner with Kovitz, Schiffer, and Nesbitt. Our firm has been in existence for over 30 years. We represent thousands of associations around the Chicagoland area. I'm looking forward to this discussion. We had a previous one in advance of this, and I'm looking forward to the discussion with Nick and Laura, and looking forward to putting some information out there for all of you.
Good afternoon. My name is Laura Marinelli. I am a partner with Saul Ewing, Arnston & Lair. We have been around for, over 125 years, and we've had a large practice focused on condominium and community associations for many years. I've been doing this area of law with the firm for almost 17 now. And I'm also happy to be joining everyone here today to talk about some of these issues and hopefully provide some guidance as we try to navigate these very new issues.
And that's 100% what they are, completely new issues, and things are changing every single day. Last week, on Tuesday, the stay-at-home order was extended from what should have been tomorrow originally to now it's going to be going through the end of April. And I think there's consideration of it going further than that. And so our first topic of discussion really comes to that stay-at-home order and what this extension means for associations and what the stay-at-home order in general means for community associations. So I think, Laura, if you wanted to start us off on that topic.
Sure. So as everyone's obviously aware of the stay-at-home order and generally what that order means, which is really requiring Illinois residents to remain at home with certain exceptions, obviously, for the most part. And for condominium associations, that really means a couple of things. Obviously, now it means that instead of having buildings where residents are in and out and probably only in their units at certain times of the day because they're going to work and doing other things, now you've got buildings where everyone is at home most of the time. And this has raised some issues with the access to the common elements, as well as use of amenity rooms and centers. And what we've seen, and I think Nick and Michael will agree with me on this, that, for the most part, I'm all of the buildings that I represent or that I've dealt with and the management companies I've talked to and the buildings that they're talking to, they have closed all of these things, such as the fitness centers. They've closed the common rooms or party rooms or rooftop areas that you might be able to rent out for activities or events with your families. In addition, it means that we're seeing some new guidelines and new procedures in place at buildings with respect to who's allowed to access the common elements, with respect to allowing visitors and people in the building to make deliveries and how those are being handled. In addition, we're seeing restrictions about not allowing certain staff into the buildings and things, and we're going to touch on some of those later. But we're definitely seeing a lot of these common areas closed down in the buildings at this time, at least.
And Laura, one of the things that we talked about before we started this was, I thought was an interesting discussion, was elevator usage. Everybody is talking about the 6-foot rule, and we're talking about the use of masks. And these are things that we're going to probably talk about throughout this discussion. But I agree that I think there's value and there is the ability to restrict the number of people that are on an elevator, because you're forcing people to be in close proximity to each other, which is very impactful for downtown, Cook County associations that are basically have high elevator traffic. So I think that falls into this discussion as well.
Yeah,
I agree, Mike. Go ahead, Nick. Sorry.
No, not at all, Laura. I just wanted, because Michael mentioned you said most of the common elements are closing down. I'm getting some questions on some of the common elements and limited common elements that cannot be shut down feasibly, such as the laundry area. And that's one of those that is deemed essential. It ought to be left open, but we're advising some of our clients to make some allowances for the 6 feet spacing, such that perhaps certain floors are encouraged to use the laundry facilities over others. They can say Monday, Wednesday, Thursday. The even number of floors use them Tuesday, Thursday, Saturday. The odd number of floors use them. And that can just, if not prevent people from using it, at least encourage those to mitigate the foot traffic and help enforce the 6-foot rule.
Well,
I agree.
Go ahead, Laura.
Sorry, I've also seen there's a little bit of a delay for everyone watching, so we're not trying to talk over each other. It's hard to not do that. One thing that I agree with you, Nick, is the laundry rooms. It's a tougher area, and obviously we especially need people to be able to launder their clothing and other items at this time. And one of the things that I've seen in some of the laundry rooms as well is we have been, encouraging people to do some additional procedures or things they might not have otherwise done, such as using wipes if they're available in the laundry room to wipe down the insides of the washing machine basins or dryers, the handles or the buttons or the coin machines, anything that you might be touching when you're utilizing this equipment, both before you use the equipment as well as after you use the equipment, for your own safety and the other resident safety. So I have seen buildings and implement some of those new procedures as well with respect to the laundry rooms. And the other thing I also have seen is the same you were mentioning about using them only on certain days. And we've got dog runs, right, in buildings where people get their dog out. And you don't want to prevent them from obviously taking their dog out to relieve itself. So I've also seen that in buildings where they are trying to limit the number of people that are in those areas at one time, to try to maintain the social distancing requirements that we're talking about here and that are part of what was in the governor's order as well. So I've seen some of those changes come into play here with these issues.
Sure.
And the thing that we actually end up running into, and this is before COVID-19, was the concept of fair and equal use of the common element, right? So, from a legal standpoint, when I get asked that question, if you're going to make the area while you're limiting its use, you're making it fair and equal to all of the membership. So like you said, Nick, about the, using certain dates and times, as long as that's fair and applied equally across the membership, from a legal standpoint, that should absolutely be defensible.
Wait, what's fair and equal mean? Does fair and equal mean that one person, one allotment, or are we talking percentage of ownership? What's fair and equal?
Well, everybody, and I can try to apply that as best I can. I'm sure everybody on this call might have a different philosophy behind that, but my idea is that, and the easiest one is the parking area. You can't limit the parking area to some people and not to all when the parking area is considered to be common element. So if the fitness room, for instance, is a common element, which it would be in most of our associations, if everybody has the same ability to use it and enjoy it, we're not talking about minutes of time, but if everybody has that same ability to use it, and one person doesn't have the right to use it 23 hours a day and everybody else can use it 1 hour a day, you try to find that happy medium. I hope that answers what you're asking, Brandon.
Mm-hmm. I think that's one thing that I think sort of been a recurring theme. I think we talked about this a little bit the other day. But I think that in this current situation, there has to be a certain level of trust with everyone, that we are all trying to be reasonable and do what's fair and try to adapt to this situation and just have respect for our fellow residents and owners and staff, so that we try to find some way to, implement some of these procedures that are completely new to us in a way that's considered fair. I think it's impossible to define that, but I think that we have to just all try to use common sense and judgment in order to be able to do some of these things.
Yeah, Laura, I think you hit it on the head. So did Michael. And I should mention that people listening are probably hearing a lot of us use language that's aspirational in language. We're trying to limit this. We're trying to do this. We're encouraging this, because it starts to become a question of the extent to which the board can actually make these mandates. To what extent can the board actually say, you're on floor 3, no laundry on Mondays? I mean, we're not at that point yet. We're at the point of strongly encouraging individuals to be neighborly and humane and follow the CDC recommended guidelines, and to that extent, follow the association's guidelines. But I think it's fair to say that none of us are advising their boards or managers to act as the germ police and tackle people if they try to get into the dog run on a day that's not necessarily the day to which their floor is assigned. We're not there yet. So again, it's aspirational at this point, but these recommendations can still be very beneficial.
Yeah, and Nick, when in the history of any of us on this has this been more true, that the thanklessness of a board member's position, because they have to make such hard decisions right now that are polarizing, where I have some people that have come to me and said, absolutely, the fitness center needs to be closed. It is a cesspool of germs. And then you have somebody else on the other polar opposite side of it that comes to you and says, I must. And I don't want to get into if somebody needs it from a disability standpoint, but the people that say, I for my own sanity, I need that exercise room. So the boards are really put in tough positions right now to make these decisions on the best interest of the entire community.
Oh yeah, absolutely.
Right.
Yeah. I will jump into that discussion. So who would have thought, I don't know, a month ago that we would have divided ourselves as a society as essential versus non-essential? I think the whole concept is a little bit odd. But as of March 20th, with Governor Pritzker's order, it really did shed a lot of light on what professions and what areas that people work in as to whether or not they're deemed to be essential. A lot of what was in there was a wait and see. I can remember very vividly talking with a number of my partners where we were kind of sitting around waiting to see the text of the order, trying to decide who's essential. Our attorney is going to be essential. Our management. I was talking to a number of different management companies, and there was a lot of concern as to whether or not their managers were going to be considered to be essential. So if you look at the order, and it's lengthy, but it has a number of different parts to it. It talks about who is essential, and we can argue whether or not in reality those are essential jobs, but they are in fact necessary for things to be done at associations, such as moving and relocation services. I answer the question probably a couple times a day whether or not they can prohibit movers, meaning the boards or the association can prohibit a mover from entering the association. And pursuant to this order, they are considered to be essential services. Also, the one that's kind of a catch-all that I think is interesting is that the quote is, other service providers who provide services that are necessary to maintain the safety, sanitation, and essential operation of residences. That is really a wide net for who would be considered to be essential for residential communities. That's going to be your janitors. That's going to be your door staff, your valet, your door person, your garage people, engineers. If you have an on-site office manager, those are the types of people that are going to be considered essential. Who's not? And this is kind of reading the tea leaves. Retail, recreation, entertainment businesses. Those are the types of things that are not considered to be essential. I can tell you that I prepared a number of letters to give to people who are deemed essential that they can carry on them, because there was a big worry that people were going to get pulled over or questioned on the street by police as to whether or not they should even be out of their homes. So, I mean, that is something you can talk to your association's attorney about, to essentially have something to carry that deems you to be an essential employee. The only other thing I think that needs to be discussed too is management. I already kind of talked about that, but management is somebody who is considered to be essential. So your managers are absolutely allowed to come out and do site visits. I saw a photograph of a manager the other day doing a site visit with a mask on and gloves. So they clearly are taking precautions. But it's important to understand what the order says and who's essential and who's not. One thing I also want to point out is, okay, so the order does allow for work to be still performed. So you can bring contractors in if they're performing work for, again, it's the essential operation of the association. The next question that is begged to be asked is whether or not individual owners can have their contractors keep coming in, which is the steady flow of workers entering your association. That also, the order says they can continue that, the maintenance, repair, and replacement projects, but they need to be necessary for the safety, again, sanitary and essential operation. So if somebody's cosmetically painting their unit, I would take the position that is not necessary, and you could, as an association, choose to try to prohibit that.
I think, Michael, too, one thing is I think this kind of gets us back to what we were talking about earlier, is that just like with many of these issues, we have to use common sense and good judgment when we're trying to interpret what this order means and how that impacts things. I've had a lot of buildings who have shut down a lot of construction projects or delayed them because they weren't, what they deemed to be essential. There was no emergency. There wasn't any going to, be damaged if they didn't move forward on the project. But we also had a couple of units that were under renovation and they were close to finishing, and we had owners or residents who were being temporarily housed and were supposed to be moving back into their primary residence within a couple of weeks. And I saw buildings in those cases that said, look, given what's going on, it's really important and critical to let these residents get back into their primary home, and they need for the work to be finished so they can move back in and it's functional at least. So I did see some buildings that allowed unit owners to finish up those projects just so they could get them far enough that the residents could move back into their house rather than being housed temporarily someplace else. So I think there's a lot that comes into looking at each situation and the facts that surround it in order to be able to determine what this order really means with respect to that particular situation. I'm going to say this again later as we talk about other topics, but I just don't think there's a one-size-fits-all answer to most of these issues. And I think it's really important. One of the other things that I think is also important to note is if we're talking about essential and non-essential workers, and management is an exception, they've been listed, certain staff members, but this order also says that to the extent that certain categories of people are considered to be essential and they have to be there to perform jobs, then you still have to be practicing these social distancing requirements. So we're seeing a lot of buildings put new procedures and policies in place with respect to the way that their door staff or their parking staff or their managers or their maintenance people are doing their jobs. They have to be on site. A lot of the managers I'm talking to, we have requested that unit owners don't come directly to the management office in person anymore. We want to limit the person-to-person contact, and that instead they submit requests via email or they phone ahead. I'm sure you guys are seeing, Nick, you're seeing these types of things too come into place, because even the way we do these essential jobs are changing with respect to order.
Yeah.
The other thing I would say, the other thing that plays off of what Laura just said is looking at the contracts. I mean, boy, we as attorneys, we look at it, we review and we provide writers and legal guidance on a lot of contracts. And who knew or who would have ever thought in a million years that we'd be talking about a pandemic and the impossibility of a contract being fulfilled, or whether or not the provision, there's an easy termination provision. And, we've always looked at that for other reasons, but because again, how would we have ever foreseen that we'd be having this conversation about a pandemic and whether or not work could actually even be possible to be done. It might actually be an impossibility for some work to ever take place in light of what's happened.
All right, so I want to interject here with a couple of questions from chat. One of them actually it applies great to the conversation that was just going on, and that's for essential versus non-essential. From Jacqueline, are boards allowed to prohibit real estate open houses?
Nick, do you want to take that, or are you good?
Oh, yeah, sure. And I'd say absolutely they're allowed to. I mean, honestly, boards are allowed to prohibit open houses even if there's not a global pandemic going on. So certainly to the extent there is a global pandemic, absolutely. And in fact, one of the biggest trade organizations and the state of Illinois has now prohibited open houses via recommendation, I believe, as of Friday anyway. So open houses, to be honest, that's easier, prohibited. The question then becomes, okay, so to what extent can we prohibit brokers from just showing a unit, occupied or unoccupied? And at that point, going back to what Laura had said, you just have to apply some common sense. Is the showing necessary for an individual to house in place, shelter in place? In most cases, no, it's not. Because an individual who's looking to buy a home generally has somewhere, an alternative place to stay. But open houses, yes, I think a board can absolutely prohibit that.
And what I would say in furtherance of that is it's weighing it. Okay, so you're weighing risk. That's what we as lawyers do. So you run the risk. So you run the risk if you prohibit a showing of somebody claiming that you've interfered with their business opportunity or the sale of their unit. So there's obviously, with all lawyers, we have different viewpoints on different things. I would say that I agree that you could prohibit showings. We've also limited the number of people who can be in a unit. If you're going to have a showing, again, as Laura said earlier, you're trying to limit risk. You're trying to limit exposure. So we've limited the number of people who can be in a unit. I know there is a real estate company downtown Chicago that is requiring people to sign off that they have, in fact, not displayed any symptoms and that they are not tested positive. So it's essentially your oath that if you're going to enter the building, that you're signing off that you are not aware of any health issues. How much that's going to stand up, I don't know, but at least it's somebody putting yourself out there that you, in fact, are not displaying symptoms. So it's some assurance to the people in the building. So that's something else I've seen recently.
I know there's also a number of brokers that, and I'm not saying that we can require this, but I know there are a number of brokers that have pretty extensive tools right now and are conducting a lot of showings, especially initial showings, to let someone view a unit virtually rather than coming in physically. And I know you're talking about a major purchase, so sometimes people really want to see it in person, and I can understand that. But at least I know that that's something that's out there that a lot of companies are utilizing, at least to try to minimize the amount of people coming into the building.
Mm-hmm.
Oh, so then I got a message here from Jessica. Jessica Tolles, our past chapter president, on this. Is there any difference between rented units and so units that they might be trying to rent out and units that are for sale when it comes to this?
I can touch on that. Yeah, there absolutely is. There's a moratorium on showing occupied units. So to a large extent, if a unit owner wants to show a prospective renter an occupied unit, say the lease is up in June and they want to show it now, there's currently a prohibition in place. So that's going to make some difference. But generally, the questions we're getting obviously are brokerage, somebody who wants to sell their home. Yeah.
So then going to another question then on this stay-at-home order. This one's from Mike. Can the board prohibit unit owners? Can you restrict unit owners from having parties in their unit? And this might also extend into a conversation I know we had last week where can you stop unit owners from just visiting each other?
No, you cannot. Go ahead, everybody.
Look, again, I mean, this again, in my mind, comes down to people's use of good judgment and common sense as far as people, you're not supposed to be having anyone over visiting you or having parties at this time under the stay-at-home order. People are supposed to be at home essential work. So if Nick invited us all over for a party, you know, Nick might not be in trouble, but Michael and I sure would be in trouble for leaving our houses in violation of the stay-at-home order. Unless we could come up with a good reason that we were doing something essential. But you cannot prohibit a unit owner from having a visitor or a guest to their unit. You know, I guess I would suggest that if you find somebody having a party in the building, I know we've heard the governor say this on a number of topics, right? If there are people that are doing things that you deem to be dangerous and in violation of the order, you know, I don't think the building can do anything to them technically, but you can report them. And I know that the Chicago police are making calls on things like now. I've seen them at the parks, stopping basketball games and stopping other gatherings of people that are prohibited at this point in time. So, you know, if you have a neighbor that's throwing a large party and you're very concerned about the potential risk it's bringing into the building, then in my mind, I mean, Michael and Nick, you might agree with me on this, but I would think that's probably going to be the quickest way to get someone's attention.
Well, certainly. So the problem we've run into before COVID-19 was what abilities does an association have to prohibit something, right? I sit in meetings and I say, well, we're not the police. We don't carry a sidearm. We don't have handcuffs, right? What we do is we have governing documents that we have the ability to use a court system to enforce. And in this particular case where you're talking about somebody's health and well-being, and we all, I mean, every day we listen to the news and we're hearing how much more transmittable this is. You know, one of the answers to a lot of questions, and it seems very common sense, is none of us are doctors, right? And even the doctors are paying attention and seeing this evolve. So you're referring people to the CDC, to health department, to the police. If we believe that somebody is risking, now it's not as extreme as somebody running through the hallways, you know, with a weapon, but isn't this virus kind of a form of a weapon that somebody is potentially, you know, exposing other people to? So I don't think it's too much to think that you could involve the police if you think that somebody is recklessly trying to put this into somebody else's close proximity. I would absolutely think the police could be involved.
Yeah, I agree. And you know, you use the prohibitions in your declaration, and if you've enacted a policy to limit unnecessary foot traffic into the building, and people are having guests in a party, you know, you can issue a notice of violation. That right hasn't stopped for boards. You could still issue notices of violations. I mean, that unequivocally is the most powerful tool in the board's arsenal. Hit them with a fine. You know, it doesn't mean you can discontinue the processes that the board has to follow to do so, but that's still the number one biggest arrow in the quiver of the board.
All right, so I want to touch on one more chat question about the stay-at-home order here before we finish up with our other stay-at-home order question, and that is as far as these common areas go, so things like elevator buttons and door handles, and can the board require, or is the board required to be disinfecting these things? Do they have, are they putting themselves at risk of liability if they're not doing these things? And let's say they wanted to put in a policy where everybody coming in needs to put on a face mask or something along those lines. Are those the kinds of things that a board needs to be worried about?
Laura was just talking about this before we went live here.
That's why I added that part.
So I guess I'll kind of take it in two parts. With respect to the disinfecting and the cleaning, as everyone knows, I think everyone right now is doing their best to try to follow the CDC guidelines and the other information that we're getting. And I'm make sure to mention again, that's changing on a very regular basis, right? On a sometimes hourly basis, but definitely on a daily basis. So do I think that the board has liability if they're not doing those things? From a legal standpoint, I think it would be a very difficult case to make, because who is to say how we would be able to trace where someone contracted this or whether they cleaned enough? No one knows exactly what's enough, right? We're all doing what we can. We're doing the best under the circumstances that we're given. Buildings are making good faith efforts to clean on a much more frequent basis and to try to disinfect those high touch surface areas that CDC's recommendations talk about. So I think there would be, some type of direct liability if somehow someone didn't think they were doing it frequently enough. No, I don't think that. That being said, do I think everyone has an obligation or should make a good faith effort, let's say, to try to do some of these things? And we're recommending these precautions to boards and buildings, of course. On the face mask issue, that speaking of the guidelines changing, that's something that I think we've all seen change just in the last few days. My initial understanding of CDC guidelines was that you didn't need to wear a mask out in public, that you should wear one only if you are sick. And in an effort to try to not spread things, we've now seen some recent changes from the CDC, as well as some of the made from various political figures about the importance now. They're recommending that you wear masks in certain circumstances or situations. So the question that's been talked about that Nick mentioned we were talking about right before we got on was the idea of could buildings or should buildings be, requiring or asking people to wear masks when they come into the building. And this, I think, will kind of come into the next topic that I know Nick's going to touch on, which is allowing food delivery and package services in. So he might have some thoughts, with this issue on that. But do I think a building can require a unit owner to wear a mask when they come out into the common element hallways or to get their meal? No, I don't think they can require them to do it. Do I think they can ask them or recommend that they do it if they're willing to provide masks? Sure. But I think everyone's going to see that we're all aware that it's really difficult to obtain masks right now, especially certain types of masks, and they're trying to keep those supplies available for our healthcare workers, which is critical right now. But a lot of people are making masks or wearing bandanas or other types of cotton covers to prevent that. So do I think you could, request or suggest that people do that if they have them available? Sure. Do I think you can require a unit owner to do that in order to come out into the hallway to get their mail? No, I don't think you can require them to do that. Nick, I don't know what you think about how this plays into the food and package delivery issue. I know you're going to talk about that, but it might play into that.
It doesn't play into food and package as much. Brandon, did you want me to go into that? Or was
let's jump into it.
Okay.
Sorry, Brandon.
Oh, no, that's fine. That's fine.
It doesn't play into food and delivery as much to what Laura was saying, because I'm not recommending, and I think that my colleagues here are probably not recommending that anybody, such as food delivery, Grubhub, DoorDash, or the Amazon delivery people necessarily be given access to the common elements. Whether or not to require a contractor to wear a mask kind of goes back to what Laura was discussing before with regard to look, we have an essential project within the unit, our toilet's non-functional, or we need water in the kitchen sink, that contractor has to come in. Okay, in those cases, we are recommending that the board say, sure, contractors allowed in, please wear a face mask and gloves. I think that's appropriate. It's a little different from requiring unit owners to do so. Contractors, in general, are going to have some of that equipment. So putting that requirement on them. And if they don't adhere to it, that's a separate issue, but most of the time they will. But with regard to food delivery, put the caveat out here that a downtown Streeterville high-rise is going to have a far different situation, probably being a door staff building, from a Rogers Park walk-up all the way to a townhome association in the western suburbs. With food delivery, however, let's talk about condominium associations, because that's where it's the biggest issue, coming into the shared common elements. Most of the delivery services now have a place where you can put special instructional notes. They should not be allowed into the common elements at all. People should either be required to come down and get the food. If there's door staff can collect it and bring it up, leave it outside the door. There's ways to use common sense to minimize any contact between any individuals. If it's not a door staffed building, that food can be left in the foyer and it can be gone. Some people can go down to pick it up. If the individual to whom the food is being delivered is being quarantined, either because of a positive diagnosis or simply as a precautionary method, they're going to have to make other arrangements. That can be anywhere from having somebody, a volunteer, go down and get it from them. I've worked with some of my buildings they've put together a kind of a volunteer, an unofficial sign-up sheet for some individuals who might be elderly or debilitated in some way, or some who just cannot leave their units. There are some individuals who are working from home who have proactively said, look, I want to be there to help. If somebody needs me to run out to the pharmacy and get them something, or if a delivery comes, somebody has to run down to the front door and grab it, I'm willing to be that person. The association should help facilitate that type of communication and that type of volunteers within the community, because ultimately the board and nor management is going to be able to handle this all themselves. Your duties have ballooned because of this pandemic, unequivocally, and some reliance on the community itself is going to be necessary here to help ensure the safety of the building. But this is all a long-winded way of saying for food delivery and package delivery, they should not be allowed into the common elements. Pandemic or no, to be honest with you, I don't think the pizza guy should ever be allowed up onto the 14th floor, even if without COVID. And with packages, folks, this is just kind of hastening what a lot of buildings were dealing with anyway. Everybody's getting everything delivered now, and it's not likely to go backwards after COVID-19 is in the rearview mirror. So if you're already experiencing a front hall foyer stacked with packages that people are or are not picking up, the board's going to have to address this, and we'll have to address this prospectively anyway. So, again, you should instruct your unit owners via communication. Do not buzz in the Amazon delivery person into the shared common element. You should leave it in some common element space, because providing access to people who do not live in the building is just against procedures. It's just inadvisable at this point, from my perspective.
Great. Was there anything else on that topic?
No, I think Nick handled that quite well. Good job, Nick.
All right. Excellent. So then what we'll move next into, we're going to jump through our agenda a slight bit over into the communications portion of our topics here. So what are boards doing to or should they be doing to communicate about the virus? And we've had two questions about this so far, and that's why I wanted to jump into it from Nadia and Christine. I think, Nick, you'd brought this topic up earlier when we were talking last week. It's the scarlet letter question. What does a board do when a resident tests positive? And I think to Nadia's question more specifically, can that person be restricted from using common elements?
No, this goes back to the issue that Michael raised. I mean, the board did not become the de facto CDC in order to become the police? And is it able to stop somebody from doing something that may be against the advice of all public policy officials? Now, notwithstanding the other items that we mentioned that Michael and Laura astutely pointed out, that then you have to call the police because they're engaging in some dangerous behavior or consider a violation, absolutely do it. But we've kind of boiled down, not just me, but kind of national, CAI National, putting a lot of good thought and good advice insofar as following its the CCAL, the College of Association of Attorneys and Lawyers. But if somebody tests positive, the communication to that individual, if they call the manager or the board to disclose they've tested positive, there should be 3 questions that are asked. The first question should be, are you self-quarantining? The next question should be, how long do you plan to self-quarantine? And the third question should be, where do you plan on self-quarantining? Most likely, the individual will be quarantining in the unit. So that answers that question. So to the extent the association has that information, they can then follow up and ask, to what extent do you feel comfortable allowing me to disclose your identity to the rest of the association? That's key. This goes to a lot of questions I've been getting from association members talking about, well, can we tell the name? Can we tell the unit number? Does this violate HIPAA? Let me just say, HIPAA doesn't apply to your community association. It's inapplicable to these, to you, the property manager, and you, the board. It doesn't mean that privacy goes out the window. We want to respect an individual's personal dignity and their personal privacy. To the extent to which that person answers the 4th question, no, and says, no, I don't want you to disclose my identity. My thought is that the board should respect that. You can still tell the association that somebody's tested positive. We could probably argue all day long the extent to which putting that information out there, that one individual is tested positive in a building of 400 units, to what extent that actually helps the rest of the building. I mean, I'm not a healthcare expert, none of us are, but we all know that 25% of people are asymptomatic, so they don't even know they carry it. And 20 to 40% of the cases are transmitted even before a person who is symptomatic starts to show those symptoms. Finally, what they're also finding is for every individual who's diagnosed, there's probably 10 individuals who have it and are undiagnosed. So that's all to say, if one person tests positive in your building, it's quite possible there are others who just haven't been tested yet because of the limitation of health supplies. So I want Laura to kind of address, because I know she's talked about staff answers, and this is very important. Laura can touch on what the association should be putting out there as far as the staff answers. But I think as a threshold matter, the information I just said that should be collected by the board and the manager is what ought to be collected. But I'll kind of turn it over to Laura, what should be then disclosed insofar as the stock letters and responses.
Sure, Nick. And I agree with Nick. You know, if someone specifically gives you permission, tells you you can disclose my identity, I don't think that anyone should be disclosing the identity or even the unit number or the floor or any other type of identifying information about anyone. With respect to the letters and putting together, you know, form letters or what information you're going to share, well, there are obviously specific pieces of information that I think are really important to put out there. I do want to kind of stress before we get into this that I don't think, and I think my colleagues will agree with me, that there's always a one-size-fits-all answer. Again, I know you've heard me say that before. So I think we have to be careful with this idea of form letters and make sure that we are in fact taking a look at the particular facts and circumstances of every situation before we send something out there. So what I'm seeing and what I'm looking at and what I've been recommending to my buildings when they have a confirmed positive for COVID-19, and I've had a number of them in buildings, is that we put out some critical information, which hits a lot on what Nick was saying the questions are that he asked. So one is, you know, are you quarantining? For how long are you quarantining? Are you quarantining in the unit? That information is going into these letters or these notices to the other residents and unit owners in the building. I'm also putting information in, or we're notifying residents and owners along these lines. We're letting you know that another resident in the building has tested positive. This person is quarantining for 14 days per medical instructions in their unit. Or in some circumstances where we've got residents who are not quarantining in the unit, who are either quarantining somewhere else or hospitalized or whatever the case may be, we are letting residents know that. So the example might be, we have a resident who tested positive. That person is being quarantined off-site at another location. Perhaps that person was traveling before they got sick and went to the hospital and tested positive. So we're checking to confirm when the last time was that they were in fact in the building or in the common element, so we can let owners know that. Because I've had residents who have returned from a trip and have gone immediately to the doctor and tested positive, and they haven't been in the building in 10 days. So everyone wants that information. So I think it's okay to give that type of information as long as you're not giving anything that would identify who the person is. But you can let other residents know you had someone that's tested positive, they're quarantining off-site, they haven't been in the building since X date, et cetera. Or if they're quarantining in the building, you can let the residents know that.
And Laura, it's really an assurance to, and this goes before COVID ever came around. It's an assurance to the owners that the board is in fact doing, and taking steps to investigate, to work with the CDC or the health department, to work with management and the professionals, whether it be the attorneys, whoever it may be, to investigate to make sure that the safety of the owners is it's a paramount thing for the association and the board. So it's really the open chain of communication that I agree with you that I think, while there shouldn't be more matters, communication is vital to make sure that they're aware that we are in fact working with that person who tested positive to make sure that we're keeping the association as safe as we can.
Absolutely. And I think that ties into, it's not just residents that we're seeing test positive. We're seeing staff members in some cases test positive, or we have staff members who might need to self-quarantine because they have a family member that tested positive. We're seeing a lot of those situations. And again, we're following the same type of protocol, is asking questions, trying to get as much information as the board can in order to, not because we're trying to go into anyone's personal information or business, but more so that we can take as many necessary precautions as possible. So if, for example, if we have a staff member that we know works in one particular area of the building, we want to know when the last time is that person was at work, so that then we have an idea of how long it's been since they might have been in the common areas or who they might have had contact with if they worked a shift with another staff member. In addition, we're taking precautions like sanitizing common areas that staff might be using, right? Computers, desk areas, certain things like that. So that's why it's important that we're asking all these questions. Again, we're not disclosing the identity to anyone, but I think it helps residents and owners feel better having as much information as possible so they can understand the steps and the precautions that the boards and the management companies are taking in order to address these situations in the safest way that we know how, which again is changing, and there is no perfect answer for every situation. It really is a situation where we have to ask questions and learn the facts of what's happening in that particular case, and then apply the law and common sense and our judgment to the best that we can to address those situations.
Well, and to kind of echo what Nick said earlier is that, you got to be really careful not to cause panic in an association as well. I mean, as Nick said, there's a good number of people who are probably walking the halls of the association. If 25% of people are asymptomatic, or they have not had symptoms yet, but they will, so they feel perfectly fine, the message should be from day one, prior to there being a positive or a potential positive test in your building, the message shouldn't change. You should be essentially pretending that everybody that you come into close contact with may possibly have the virus. So it's really a bigger discussion than, because my concern is you give somebody, and somebody might have said this before, is a scarlet letter. And that, by the way, that scarlet letter is going to stick with this person potentially far into the future. That if you were to name names and that person doesn't want their name out there, you run the risk of that person being, you say this person tested positive, and that person might have social issues in the community for months, years to come because of that information. So that's a consideration as well.
There's one other thing, Nick, I wanted to touch on that you kind of brought up at the beginning of that section, which was the idea that, we're not the police, right? Obviously, the association can't stand outside of someone's unit and, barricade them in their unit if they've tested positive. But I do think it's important, that we still take necessary steps to recommend and tell owners. I've had cases where they're confirmed where we've told those owners, we don't want you leaving your unit. We want to make sure that you're not coming down to get your mail or you're not coming down to get your packages. We're working out procedures so that, like you were talking about earlier with volunteer lists, where we're setting up a way that we can get their mail to them every day. We can get their packages delivered to them. We can get food deliveries to their units. We can make sure we're taking those steps in order to, remove any reason they might have to leave their unit for their own safety and the safety of the other resident. So I think it's important that buildings are talking about those types of ways to address these issues when they have a confirmed resident, for everyone's safety.
So I can actually, Brandon, I can kind of move us into the next topic, which is
absolutely. I was just going to ask.
Yeah, as it relates to avoiding FHA violations. So understand FHA is the Fair Housing Act. It applies to community associations. And one of the big things that we as attorneys, managers, boards deal with is something under the FHA that's called a reasonable accommodation. So as Laura said, we deal often, where we look at the situation, is it can't be one size fits all because everybody comes to the board and comes to the association with a different set of facts. And sometimes those facts are disabilities and the need for what's considered, again, a reasonable accommodation is something that they might come to the association. But for instance, the association could have a rule that says no pets in the building. And we as attorneys deal with it quite frequently where there are circumstances that somebody may have the right to a reasonable accommodation to allow them to have a support animal or some other accommodation, whether it be a ramp or something along those lines. So on those circumstances, we look at a ton of facts. We look at is their condition apparent? Is it necessary for the use and enjoyment of their unit? In this particular case, one of the things I've been facing, and I'll ask the other attorneys as well, what they've faced, but I've had people come to us say that they must, again, use the pool or the exercise room. And that's where the association has a bit of a balancing act to do, because one of the caveats to a reasonable accommodation is that the accommodation can't cause a financial or administrative, an over or unnecessary burden on the association administratively or financially. So depending upon what it is that they're seeking, for instance, if you have a closed pool and that person says, I need to use the pool, and they're the only person who would be using the pool, meaning from an administrative standpoint or a financial standpoint, you would have to be spending time, money, having staff, everything that goes into having the pool functioning for that one person. It would be my position that you could make a strong argument that accommodation is not reasonable. So the takeaway would be is, again, and we've kind of beat this to death, is that there is no one size fits all. We need to be looking at the circumstances that go into reasonable accommodation requests. But that's what we're getting now is it's not the easy fact pattern where it's somebody asking for something quite simple. And that's where we all have been saying common sense, do what's right for the masses. These are the little fact patterns that we get that cause us to, we talked for an hour last week and all the different things that the three of us attorneys were facing. And that's the kind of stuff that kind of gives us pause and is difficult for the boards.
Yeah, I think Michael's right. And this is exactly the type of situation where we really have to look at the individual circumstances. And every building is different. The makeup of the building is different, the way the amenities are set up, and what types of accommodations may or may not be possible given the totality of the circumstances that we're facing here. So I think that's a critical issue that you really need to talk to your legal counsel about so you can really explore the full extent of the facts and the circumstances if you have a situation like that.
All right. So I think another thing that came up when we had discussed this before was the possibility of no-win scenarios. where you could end up with somebody having, it comes up with the pool example that you gave, Michael, where you can't accommodate somebody's request. And I guess the question that comes out of that is, at what point do they make that decision? Is it after they consult with you, their attorney, that you really find out, it's unreasonable, we can't do this?
Well, yeah, because there are specific guidelines and there are specific things that have to be met, hurdles to be met before you have an obligation to provide a reasonable accommodation. That absolutely is a legal analysis. So I think that the association's board should be working closely with their attorney to determine whether or not the accommodation should be granted. As I just said, whether or not it's a financial or administrative burden, that's a gray area to determine what is a true burden on the association. So it's not a simple plug and play where you're going to come to me and I'm going to say, oh yes, you must, you must or you must not give an accommodation. There's a human element to it that you're going to look at it with with the attorney's advice to decide what's the proper course of action based on what you know.
Mm-hmm.
And keep in mind, because I think this kind of ties into the next topic, Brandon, but keep in mind, everyone, that consulting with your legal counsel does not require you to notice a meeting and hold a board meeting. That's outside of this pandemic. That's always been one of the topics that under the Condo Act, you're allowed to have discussions without it being in the context of an open meeting. So if there are situations where it requires legal counsel, the board and management can get on the phone with your attorney and have these discussions without the need to call a meeting. So, this is something that you can do pretty easily. And given the circumstances right now, which are making, questions like this, which may be challenging in a normal environment, they're making them even more challenging. I think it's even more critical that you be consulting with your legal counsel before you would take anything that might involve any kind of a fair housing issue. And I was saying that kind of leads us, Brandon, if it's okay, into the next topic, which you had asked me to talk about, which was whether or not what's going on really has any impact on the open meeting requirements or the need to have board meetings and unit owner meetings right now, given the current situation. So there's nothing in the order that says you don't have to have meetings anymore as required, or you don't have to take a formal vote on certain issues in an open meeting under the Condo Act. There's nothing that specifically addresses that, but there are a number of practical things that have some changes now given this, which is that we're allowed, and you've always been allowed, to conduct meetings, board meetings, via telephone or video conference, as long as you allow unit owners the ability to call in and listen and be able to observe and hear what's going on, what the board is taking. And you could have done that even before the pandemic, but that's especially important right now because obviously we can't be holding meetings in person given the current stay-at-home order. And so we're seeing buildings who are holding their meetings via telephone or via Zoom, sometimes with video conference, through all these different platforms. What I have seen also happen is that a lot of buildings are not having meetings as frequently unless there's something really critical on the agenda that needs to be addressed. Now, there are some buildings that do have to have a meeting, right? Their declaration requires they hold an election or an annual meeting at a certain time of the year or within a certain time period. And we're people try to come up with ways to address those issues. So you still need to make sure that you're following notice requirements while you're if you are going to be having a meeting. The order hasn't removed those notice requirements. That's going to be easier in buildings that have adopted or have owners that have agreed to electronic notice requirements, things of that nature. So if you have to have a meeting or you're approaching your annual meeting, I have a couple buildings who are getting ready for elections right now. I would suggest you talk to your legal counsel about the ways that you can streamline that process, how you might want to do that meeting so you can have it done virtually rather than in person, obviously. The other thing that I think is important to note is that there is a section in the Condo Act that has always been there. It's not anything to do with the pandemic, but that does allow, it's 18 to 821, that does allow board members to take action in the case of an emergency without having called a meeting, so long as they do a couple of things after they take this emergency action. And that requires that they then provide notice to all the unit owners of the emergency and the actions that they took. And then it also requires that that has to be done within 7 days, first of all. And then it also requires they ratify that action at a subsequent meeting that has been properly noticed. Now, keep in mind, an emergency isn't going to be, it was too difficult for us to call a meeting, so we decided to hold a meeting to talk about whether we should hire a snow removal company for next year outside of an open meeting. An emergency truly is, the way it's defined, is an immediate danger to the structural integrity of the common elements or to the life, health, safety, or property of other owners. So I have seen buildings utilize this in the case of a flood. I had a couple of buildings that had floods in the last few weeks during the stay-at-home order. So it is possible to, utilize some of these provisions in the case of an emergency. I think these current circumstances definitely change that landscape a little bit, but we still do need to be complying with notice requirements and making sure that we're following procedure, taking votes in open portions of meetings, and allowing residents unit owners to be able to witness what the board's, actions are and what steps they're taking.
So a clarification question that came up in the chat here from Bob on posting meeting notices. So it sounds like their policy might be to post physical notices around the building when they're having a meeting. Is there a difference in what they should be doing now, or is there some general leeway into how meeting notices for an open meeting should be communicated?
So there's nothing that's been adopted. I mean, Nick or Michael, you can weigh in if you disagree with me, but there's nothing that's been technically adopted that alleviates the notice requirements you have under the act or your declaration, whatever those may be. And so with respect to posting notices, what I would say and recommend is that I think it's still possible to post notices while following the social distancing requirements. Management and staff are essential to buildings, and if you need to call an electronic meeting or a telephone meeting, you could still have someone, post something on a billboard or in a hallway or in an elevator, wherever they might be doing that. So I think I would recommend that you still comply with those requirements and post those notices to the extent they're required, depending on what meeting you're having. I don't know if you're Michael.
And the only other thing I'd say about that is, as far as, there's obviously been a push to use technological means over the last couple of years, but if this isn't the poster child for the need or the desire to move in that direction. So I have some associations in the state. What the statute says is that you need to have a rule and people need to opt in to receive electronic notice. So that protects somebody who doesn't have access to a computer or to technology. You couldn't force that person to accept an email as proper notice. So associations, if they haven't in the past, this is obviously a reason to, as we all are going to probably change the way we conduct business in the future. I think that, the three of us in our prior discussions believe that more and more meetings are going to be held telephonically or by use of video conferencing. And the use of technology is that associations should be investigating with their legal counsel how to put the rules in place and how to get everything up and running for electronic notification, because the statute has said what it says about notification for decades, and they didn't contemplate the technology that we currently have. So I think that this is a really good reason for potentially new legislation, but the legislation as it is now, or as the statute says, it allows for electronic communication. It just needs to be done the right way.
Agreed.
Brandon, should I go to the next question, or is there anything that, this is probably, I think Michael and Laura might be one of the number one questions I've been receiving, because, look, everything Laura said and what Michael said, and insofar as how the legislation was drafted, we can all pretty much put a Jackson on the table and bet that the legislature was not considering the fact that at some point there could be a pandemic that required everybody to maintain a distance of 6 feet from one another, or else might kill that person. So that's all to say there's a little bit of wiggle room here insofar as what's required. Laura's right. Nothing's gone out the window. To that individual question on the chat room, we still have to post notices in the common elements. Yeah, you should. You absolutely should. I think what the question you've asked, Brandon, and what I'm getting asked from my association is a little bit more into the gray area, which is, well, what can we do if we screw up, if we don't rely on the emergency action provision that Laura mentioned previously? And we just say, okay, the board's putting an executive decision out there. No, we didn't do it in an open meeting. No, there was no notice. But we talked to our attorney, and we are closing the fitness room starting at midnight tonight. And when that unit owner comes back and says, well, I didn't get notice of the meeting at which the board decided to do that. Or a unit owner, I'm getting a lot of this as well, a unit owner says, I didn't get notice of the meeting at which you decided that my contractor is no longer essential, and thus I can't get my new countertops put in. Those people have a point. That doesn't mean I didn't recommend my board make those decisions in the interest of the health, safety, and well-being of the association. That simply means that the board might have to do a little bit of ratification at a later time. But to be perfectly frank, that board might not have been following to the letter the requirements of the Palm decision or the requirements of the Illinois Condominium Property Act. They will try to do their best, though. And that's the takeaway here. If the board's not making a good faith effort and using this as some kind of excuse, so like what Laura said, oh, nobody's motoring the shop, let's just all have our meeting on the phone the way we did years ago and approve the snow contract next year, and we don't have to put notice out there. That was a pain in the ass anyway. That's not what we're saying you should do. We're saying that to the extent you're working in good faith to do what's in the interest of the public health and well-being of the individuals, there might be a little bit of wiggle room, but you should still adhere to the requirements to the extent you can. One prophylactic measure that we discussed, I think, Laura, you brought this up when we were all talking last week. We kind of jokingly referred to it as the association martial law resolution, meaning it's a delegation resolution. And we've talked about this before. I'm sure many of you have heard this from your attorneys, which is delegating the authority to the property manager or 1 to 2 individuals on the board so certain actions can be taken in between open meetings. Waiver of the right of first refusal, settlement of certain collection actions up to a certain dollar amount, putting individuals in collections once they're 60 days past due, so on and so forth. That kind of delegation could be very valuable here, and I strongly recommend that a board call via telephonic meeting, the way Michael said, a properly noticed board meeting, and delegate authority to a board president or the manager or some individuals on the board to whom they can put some trust, so these executive decisions can be made. Because we all know everything's changing day to day, hour to hour. You can't call a properly noticed board meeting every 48 hours. It's too administratively burdensome on the board. So there should be some delegation here to ensure that everybody's doing their utmost to A, adhere to the requirements of the legislation, and B, ensure that everybody's staying safe and healthy as this situation develops.
Agreed.
Well, and where that doesn't work too, Nick, is, and this is where the legal lawyers get involved in this, is when Palm came out, we all talked about associations that have boards and members that all generally get along. They're not going to have as many meetings because they can have a delegation resolution put in place because they trust people. It's when you have a board or an association where there is a divide, where they don't trust each other and they don't get along, there's going to be problems because you're going to have more meetings because you're not willing to make those delegation resolutions like you just discussed. So there's really different types of communities that we deal with, that we see that some of them absolutely cannot avail themselves of that option because they simply don't trust each other.
All right. Michael, you just brought up case law by name, the Palm case, right?
I did.
Can I get a little bit of an explanation? I'm not 100% familiar.
Yeah, because that could be a 2-hour or 4-hour or 8-hour discussion.
But just the high level as it applies here. Yeah.
The general takeaway as it applies to what we're talking about is essentially transparency and the need to have decisions, discussions, take place in open meetings. Now, the legislature has dealt with Palm a little bit over the course of the last few years, but the takeaway is in the Palm case, essentially, the courts held that all of the board's decisions and discussions, to a lesser extent, but everything should be taking place in an open and noticed meeting. So that really does tie into a lot of things that come out of this, because from this virus, people are not allowed to be close to each other. We're not allowed to do a lot of the things. And frankly, the court may have had a different take on all of this if the COVID virus had happened before the finding in the Palm case. But the takeaway, though, really is from the Palm case is that you had to be doing these things in open meetings. So as attorneys, we found or try to find workarounds, one of them being a delegation resolution that Nick brought up.
And Michael, if the delegation resolution can be tough, I'm sorry to hear you have some of your board that don't get along. I mean, mine personally, they all get along and meet every night for drinks Friday, and they just love each other. I don't have.
They all bring a dish to pass. I know.
They all bring a dish to pass. They sing. They make s'mores over a campfire. It's just very easy for you.
In all seriousness, though, I just want to make sure. I know what we've all talked about with these delegation resolutions, but just to make sure everyone out there is understanding, we are not in any way suggesting that you delegate the board's authority or decision-making power to one person generally on all these topics. I just want to be careful because I know we're talking about Palm and all these issues that we've discussed with respect to the board's ability to delegate. We know what we mean, and we mean in certain circumstances. And Nick gave some really perfect examples of where that might be applicable. And you should talk to your legal counsel about these issues before you do them. But it would be in a situation where perhaps the board decides, okay, while we may normally, issue a 30-day demand letter after 45 days or something like that, if people are behind in assessments, perhaps they make a decision that right now they're going to extend that and it's going to be 60 days or 90 days, kind of general things like that could apply to everyone, or the approval of payment plans that have a certain mathematical formula in them so that people are caught up within a set period of time, something of that nature. So making sure that, we're not kind of throwing out there the idea that you delegate all your decision-making power to one person. We're not suggesting that. We're just simply talking about possible ways you might be able to alleviate some of the burden on the boards right now, given the current circumstances that we have.
Thank you, Laura.
So a specific question that came up regarding these authorities from Mimi again. Would these emergency powers include any ability to add new rules or anything to governing documents? I'm going to assume no, but I will let you guys take that as to why.
Well, the answer is the Condo Act has a process in which you have to use and follow to adopt reasonable rules and regulations. So that authority could not be put out to one individual because of the process that's set forth in the Condo Act.
Yeah.
So Laura's segue, if you don't have another question, Brandon, was actually pretty good to go into the discussion on finances. Is that okay?
It absolutely is. So I think our next topic of discussion is definitely the eviction order processing and enforcement. And so, Michael, if you want to kick us off with that.
The actual topic, the next one that she kind of led us into was the finances. Do you want to go back up to?
Let's go up to the eviction order processing and enforcement. It's the start of our finance section.
Got it. Okay. So I think that everybody agrees or should agree that the assessment collection for your association is the lifeblood of your association. So you're right. This does overlap a bit with finances, but the whole idea is the concept of collection of assessments. It's one of the major things that we as attorneys deal with, and that's when people don't pay their regular or special assessments. One of the questions we're getting now because of the stay-at-home order is whether or not associations should be proceeding with collections. Should they be essentially doing nothing? Again, kind of tiptoeing into the financial discussion. What can they do for their members? There's a lot of discussion of compassion. But from a legal standpoint, the advice that we give, and I think that this is true of the other attorneys, but I'll let them speak for themselves, is that you have to remember that this is an association that is a not-for-profit corporation that has very specific things and obligations that it needs to do. It has contracts that it's engaged in, and none of that stuff can be done. None of the functions of the association can move forward without the collection of assessments. From a legal standpoint, the orders by Governor Pritzker do not impact the association's ability to turn over collections to the association's attorney. So we're still advising that the association still turn them over. What that means is that that a notice goes out to those who are not paying their assessments based on the collection policy of the association. Every association has their own policy as to, is it 60 days? Is it a certain amount of money that's owed? But you should still continue to follow your policy. And what will happen is that you would turn that over to the association's attorney. A statutory notice would be sent to the owner. Again, it would be seeking payment, or it would be potentially entering into a payment plan. Right now, what we do know is that the courts have essentially a moratorium on filing of the collection lawsuits. Cook County, I think it is now May 18th that I just saw, and the other counties are currently April 30th. So as long as your initial court date is outside of that, you actually can file and can proceed or begin the process. So you first do a notice. After that notice expires, you can file a lawsuit, but you can't be in court until after those dates, because frankly, the court systems aren't open. So you can get the matters going forward. The benefit of doing that is it's going to put you in front of all of the other people. If some people are sitting back and waiting, they're going to be filing after you, and they're going to be getting into court after you. So those are a couple of things that I think should be taken into consideration. And from our position, you should still be mindful of the non-payment of assessments and acting accordingly.
Michael, I think we might also just want to, I just want to make sure we point out the fact that right now, the other thing that there is a moratorium on is for the ability for the sheriff to enforce any orders for possession or eviction orders, I should say, now in light of what's going on with the pandemic and the stay-at-home order and the closure of the courts to a certain degree. So we are, even though you might have an eviction order that the stay expired right now, you're not able to have the sheriff actually enforce those at this point in time. But Michael raises a good point that, especially given those circumstances, we are going to have a backlog of everything as we move forward when we finally do come out of this. So, that is going to take them some time to catch up on things. So you might want to make sure that you get yourselves in line, essentially, on moving forward in order to kind of expedite that process if you need to.
Yeah, agreed.
So then with all of these dates, there could be local ordinances on the courts or enforcement, and there could be county, there could be statewide. I don't know if there's anything nationwide as far as all of these go. How are associations to keep track of all of these dates, and which dates are the most important?
Well, it's state and county, and frankly, and we've touched on this a few times, these are moving targets. Okay, so these dates continue to get moved on us, and the single best way, Brandon, to answer your question, is to continue to stay in contact with your association's attorney, because we are actively monitoring the flood of information that is out there. I know CAI is doing the same thing, and we're all trying to keep all of our clients and CAI is best abreast of what's going on. But the dates are changing. And frankly, the Cook County one, I think that was quite recently, got moved back to May 18th for the courts. So I envision a number of the other counties doing the same thing in the relative near future.
Agreed.
Mm-hmm.
Excellent. So then, as far as that's owned units, what about for units that are renter occupied? Is there any difference in these orders for units that are owned by the association member, but they're renting it out to somebody?
Well, to a large extent, I'll jump in here. This goes back to what I think you said Justice Towles asked. the association should be paying rent within their units the same way they have in the past. And to a large extent, just because of the pandemic, it doesn't mean that the association steps into the shoes of the unit owner and the landlord. The unit owner is still to some extent, the point of contact with the tenant. Not always, of course. The management discusses things with tenants and so forth. They're the occupants of the building and things like that. But insofar as, I don't know exactly what the question is, Brandon, but is it if the tenant is violating the rules and regulations or the governing documents? If anything's changed, the answer to that is no, it ought not. I mean, violations that implicate the behavior of the tenants would still be a notice of violation going to the unit owner. If the association has not given up or lost any of its power to levy fines against the unit owner for a violation of the unit owner's occupants, tenants, guests, pets, or otherwise. So no, that's business as usual. I mean, perhaps the biggest enforcement, the biggest means of enforcement the association has is to evict the Condo Act or the Declaration, evict a problematic tenant. Obviously, as Laura said, evictions are suspended at this point, but that doesn't mean that the association can't issue a notice of violation or a notice to the unit owner that if the tenant does not discontinue the behavior that's causing the violation of the governing documents, the association is not going to proceed with not only fines, but if and when it's once again available to them, filing an eviction action against the tenant and making the unit owner pay.
I agree.
All right. Excellent. So I think then looking more at the whole finances question, Michael, do you want to talk a little bit about what boards can be doing to alleviate the monthly assessment difficulties that some residents might be having? We've been seeing the largest spike in initial unemployment claims, and there's going to be people that are in a very difficult position. What can boards do to be compassionate for their unit owners and still be meeting their fiduciary obligations and not violating the state acts governing community associations?
Sure. So we've kind of tiptoed around this topic, basically almost everything that we've been talking about. And I'm certain that the other attorneys on this conference as well, so Nick and Laura, agree. Assessments in collections and the finance is one of the biggest things that we deal with now, because I've been contacted well before it even necessarily reared its head. So think about this. April was the first payment that anybody would have probably been affected by a loss of a job or the actual change in the economy. So people astutely were in advance of this. So late March, I was already getting contacted by boards saying, what can we do? We want to waive assessments. We want to do whatever we can for our people. And this was before people had even not paid. Okay, because April 1st would have been the first payment where somebody would have felt a financial pinch, and they were already out in front of it. So, I mean, there's a lot of people asking really good questions. From the legal standpoint, you don't have the legal right to waive assessments, and that's regular assessments or special assessments. So the concept of saying, you know what, we're just not going to go collect assessments this month, and there's not going to be anything done about it. You can just all keep the money in the bank or spend it however else you want. That is not a right that you as an association have under the law. So that's the most important thing that you explained, or we explain to our clients, is that fact. So then you start asking, what are the things you can do? Because you certainly want to be compassionate, or you want to try your best to do that. Because everybody to some extent is feeling some financial strain because of what's going on. Things you can do that we've been talking about, you can offer payment plans, okay? You can talk to them and say, you know what, we aren't going to pursue, or we're going to change our collection policy, and we're not going to pursue it until 90 days or 120 days. So essentially, you're allowing people a little bit more time before you do actually actively pursue them. You can offer to waive late fees or interest. Those are the types of things that you have the absolute right as an association to say, you know what, we're not going to pursue, or we're not going to charge you late fees. So if you choose to not pay your assessments, there won't be anything additional on top of that. Another really novel thing that somebody came to me with is the whole concept of an association stimulus package, right? So the government is talking about issuing checks to every individual. And somebody came to me from a board and said, what do you think about the idea of us returning some of the portion of the budget that we're not going to use? Okay, because maybe you're closing the pool for the year and now you're not going to need the budgeted money for your pool. And I thought, wow, that's a really interesting concept. The idea of essentially finding money that you weren't going to use in your budget and potentially return that. And my answer was, I think you can do that. I think you'd have to amend your budget to reflect that that money is no longer earmarked for that particular issue. But I think you could do that. And I think you should talk to the association attorney if that's something you want to explore. Here's the big thing, though, that I want to make sure is discussed, because everything I've just said so far is about how you can not or be compassionate and take steps to not collect. There's pitfalls. If anybody was around for the last economic downfall in the 2007, 2008, 2009, there's dirty words such as foreclosure and bankruptcy. And those are a couple of things that absolutely can come back and bite an association. What that means is that if you decide to sit back and not try to collect, and you give these opportunities to extend this out and not make people pay, one of the things that might happen is that person might go into foreclosure, or they might file for bankruptcy protection. In each case, the association might not be able to recover that money, all of it, or any of it in the future, depending upon the circumstances. And guess who gets stuck holding the bag then? The association and all the members who did pay. So you really want to be careful and understand as a board that you're acting in the best interest of the community as a whole and as the not-for-profit corporation. What's in the best interest of that entity and its members? And that's a balancing act as to being compassionate or doing what's in the best interest and making sure you collect the money and not penalize the people who are paying and are taking it seriously and doing what they can, while also trying to be, compassionate and assisting those who can't. So there's a lot there that I just said. I just think that it's a discussion to be had with legal counsel, and it should be an open discussion with the board about what's the best policy for that association.
Michael, I agree. I think you raised some really important considerations, and it's a very dangerous game sometimes when you're talking about these issues. And Brandon, if you don't mind, I think that kind of actually leads us into the next topic that you asked me to touch on, which is something that boards can be doing, which might help to alleviate some of the pressure when it comes to finances on its unit owners. And that's with respect to, boards or buildings that are considering or planning special assessments for projects. So, we talked earlier, Nick and Michael and I were talking earlier about this. And again, there's no one size fits all answer, because this question really the answer is going to depend on where you're at in the process. But one of the things that I already have boards talking about is ways that they can be more careful about spending, right? Knowing that they're going to have a lot of people impacted by this from a financial perspective. And so it's things like perhaps they were considering or talking about doing a renovation project to the common areas. They might have been wanting to, do some work on their gym area or their lobby or some other projects or other non-urgency projects. Perhaps there's just maintenance projects that they've been looking at to do for the next year or two. I know a lot of buildings are considering whether they should postpone those right now because they do think and understand that their owners are going to have additional financial pressures. So perhaps considering a special assessment in the next or in the near future may not be the best idea. So the buildings are making those considerations and looking at long-term. Of course, that raises a couple of concerns, which is obviously boards still have an obligation and a fiduciary responsibility to be maintaining the common elements and carrying out their responsibilities. So we don't want to do anything that's going to end up having, like Michael said, a bigger long-term impact on buildings. So we don't want to be, penny wise, pound foolish and, not do some maintenance that might need to be done in the building in an effort to save a certain amount of money now, if it risks a much larger project as a result of that work not being done. But for things that may be optional or perhaps aren't needed in the immediate future, we are having a lot of buildings consider what projects they might be able to push off or postpone in order to alleviate a little bit of the financial pressure. The other issue we talked about is, again, it's going to impact on where you're at in that process. So it's one thing if you're just talking about or considering approving a project or voting on one, or perhaps you haven't signed a contract yet with a contractor, but we've got buildings that already signed contracts or have signed bank loans and have taken money off the line and are about ready to start those projects. So depending on where you're at in that process, there are a number of issues that you have to look at. We have to look at the contracts you have with your contractors to see what kind of penalties there are if you postpone. We need to look at the bank document, the loan documents, to see if you prepay that loan, you don't go ahead with the project, are there going to be any kind of implications? So again, it depends where you're at in the project or in the process. It depends what, documents you've already entered into, what agreements and what those documents say. So it's really important to talk to your legal counsel right away about those projects and how you might be able to, make the best decision from a financial perspective for everyone in the building before you start making decisions on those issues.
Great. Agreed. Brandon, would you want me to touch on this last hot button issue?
Sure, definitely. So then the last question that comes to mind would be, considering the fact that there's going to be this economic stimulus and everybody's going to be getting their $1,200 check from the government against their future taxes, right? The associations that are looking at projects right now, would they be in a position then to consider now as a time to schedule one?
So the question is, we discussed, can the association schedule the special assessment to align with when the government is stimulating all these individual unit owners via a check in their bank account?
Yeah, basically the most evil thing that I could imagine as far as a question goes.
Yeah. Legally speaking, yeah, sure. The board can certainly adopt a special assessment within its constraints under the Illinois Condominium Property Act, the declaration, of course. But my goodness, that would be a politically fraught move. That stimulus is specifically for individuals who may have been laid off, who need money to pay their bills. Of course, that includes the association, but it doesn't necessarily contemplate some of the capital expenditures that Laura was discussing that could potentially wait for another day. So there should be intermediary steps to follow that Michael touched on and Laura touched on before you start raiding the bank account of the individual unit owners to shore up the operating of the association. And that can include, like Michael said, going into the reserve account, borrowing from reserves. Laura can, and Laura mentioned deferring some maintenance, but doing so in a manner that obviously continues to honor the association's fiduciary responsibility to protect and preserve the common elements. So legal answer, yes, you can do it. Political answer, probably not a great idea unless absolutely necessary to keep the associations all the time.
I agree. And Brandon, I know you were trying to come up with the most evil thing you thought someone could do, but I just want to say that, all joking aside, I've been on the phone, I don't even know how many hours a day, pretty much 7 days a week, as I know you guys have been dealing with boards and managers over the last few weeks as this is all unfolded. And what I've really seen above and beyond is I've seen some really great human behavior, which is boards and unit owners really wanting to do what's best for themselves and their neighbors and their buildings and their communities, and really thinking outside the box and trying to find ways not to try to cheat the system or work it in a way going to benefit someone in particular, but really trying to work out solutions that are really, really for the common good of everyone and keeping everybody as safe as possible. And that to me, I think has been probably the highlight of all this when there are not a lot of highlights going on right now. But I think we've seen some really great behavior from everyone involved and people really working together on these issues. So I think I'm hopeful that your scenario won't play itself out.
Yeah, definitely.
Yeah,
Great. So,
it's a bit of a silver lining because, the association attorney is not generally called until something's really wrong or something's really gone off the rail. But the extent to which you see communities coming together and helping one another, that's been nice. Yeah, I echo what Laura said.
Great. So I want to take a couple minutes here. I know, Laura, that was maybe the start of your closing thoughts on the subject here. But as far as these COVID-19 related issues go for community associations, what are some closing thoughts that each of you guys would like to share?
And I think, again, I know I've said this multiple times, but this really is just a constantly evolving situation. And I know that Nick and Michael and I talked about this last week when we had a call at length to talk about kind of the major issues that we thought would be helpful for people to hear about today, is that we're all in new territory here for the most part. Yes, we know the Condo Act and we know the law as we knew it before the pandemic, but things are changing on a very, very constant basis. So the best thing that I think you can do is to keep that in mind and to be talking to your lawyers, talking to your managers, talking to your boards, and really trying to figure out, the best way that we can all come up with new ideas and work together to address these issues, because many of these are issues we've just never had to encounter before. So everybody's really in new territory.
Yeah, and I would say, my closing thoughts are, and I find it very interesting. So the three of us, we talked last week, and we all admittedly come from three competing law firms, but we had a very good discussion, and it really was, three people who are coming from their own homes. I mean, this is how things have changed. I mean, we are all sitting in our own homes right now, working through different things that are happening as we've been sitting here. I'm sure all three of us have had our inboxes fill up with questions about things that are going on, or something that the president said, or something the governor said. So this is evolving, and we, even as from three separate firms, we all benefit from kind of working together and understanding what different people's perspectives are. And it's kind of one of those situations where we're there for people. We're trying to be there to answer questions as best we can. We're going through the same things you guys are. We're experiencing the same things in our own homes, the anxieties, dealing with families, with school. So it's one of those things that's really, kind of eye-opening to kind of work through these issues together in a kind of a team atmosphere with management, the board, with legal, and whoever else you're working with. So it was my pleasure to be part of this. I enjoyed it.
Yeah, and I'll just say I agree. That was the best part of it. I mean, like Laura said and like Michael said, it's been a pleasure just because we're all in new territory and we have to rely on each other as colleagues. And it's been fun. I'd appreciate it. The one thing I want to add is, if I have a closing thought, it's just to the managers and boards out there. And it goes back, there's not a one-size-fits-all answer to this, which is, if you see that the association down the street has issued some kind of communication or a letter or has followed some kind of guidance from their attorney, and then it gets passed around all the other property managers, and everybody gets very nervous that they haven't done it, and thus they might be left holding the bag or expose themselves to some liability. Just remember that there's not a one-size-fits-all answer to this at all, not only for associations in general, but different types of associations. So continue to talk to your lawyers. This isn't an effort to gin up business, to continue to have calling out just that what works for one association doesn't necessarily work for another. And you just have to rely on your individual professionals, your hired professionals, to help you discern what circumstances apply to you and what do not. That's what I say.
Agree.
Right. And I guess my closing thoughts on here are just thank you to all three of you guys for coming here onto the call here, and we worked through getting this live stream pulled together, and you've all been awesome. And thank you to the nearly 300 people that tuned in at some point here today. And watched this this live stream with us. It's been a lot of fun doing that. I know this is the first time that I put on a collared shirt in a couple weeks, and I also had to do a shave. It's been a while since that. I was considering getting rid of the goatee right here, go for the Joe Exotic look, because I know that's that's been hot right now, the Tiger King. But yeah, thank you guys for everything. Thank you. And I hope that this has been helpful to the viewers. And if you're listening to this after the fact, keep in mind that it's been at least a day. So not 100% of everything may still be up to date. So just as general guidance, I hope that this has been of value to you. And I guess with that, we'll sign off.
Thanks, Brandon. Thanks, Michael.
Thanks,
All right.
guys.